point in time. So some of you will already know myself. My name's Jamie Watt. I'm a partner at Harper McLeod, and I lead our IP&T team, which kind of music and entertainment falls within. I've got my colleague Laura McCorkadale with me, who is with another member of that team, but also one of our litigators who deals with a lot of the more contentious side of things, which is relevant, of course, to when you're looking at unexpected events and staying in a contract, getting out of contract, and dealing with the consequences of when you're unable to perform a contract, which is what we're going to talk about today. So a bit of housekeeping. For those of you who haven't been on a Zoom call before, there is the ability for you to ask questions, and you do this by raising your hand. To find the ability to raise your hand, it is somewhere up on here. So
I think there's a bar at the bottom of your screen, guys. I think it says reactions.
Okay.
And I think it's in there. Otherwise, you can just physically, we can see everyone anyway. The reason for it is Jamie has the ability to unmute people, so that'll be why.
Yeah. It's here. I've got it now. Sorry, my screen's a wee bit minimized, so my raise hand button has disappeared a little. Okay, excellent. If you do have questions, it's absolutely encouraged, and we welcome you to ask these. As we go through the presentation, don't feel that you need to wait to the end. Also, the relationship that we have with the Musicians Union allows its members to ask us questions on an ad hoc basis, just during the normal course of a week, to be honest. Our advice in that respect is not chargeable. So, I mean, feel free to pick up the phone and ask us miscellaneous queries. If we know the answer, we can have a chat with you about that. If it's something which will require us to look into something in a little more detail, we can have a chat about what's involved with that. But yeah, I mean, we are here to answer questions on an ongoing basis, whether by telephone, email, or whatever means you choose to enjoy to do that. So, okay, excellent. If we move on to the first slide, Kira, that would be great. Okay. So, what we're looking at today is essentially events beyond your control. Now, the kind of things that we're going to cover off here, to be honest, will be known to a lot of you already, given what has happened over the last few months, what's happened in the UK since February. So what's going to happen when you've gone into a relationship? You've made an arrangement with somebody to do something like, to record an album, to perform at a particular event, or to deal with, sorry, I'm just having a little IT issues and clearing my screen here. If you give me 2 seconds. Okay, yeah, sorry, yes. I mean, what you do if you've agreed to perform at an event, for example, could be a wedding, could be a gig, a general gig. What if you've contracted to go on a wider tour? What if a person that was going to record and release your album no longer wants to because certain things have come up that make it either impossible for that to happen, or kind of not advisable for it to happen, or the person on the other side or you just doesn't want to do it anymore. Now, we mentioned the pandemic. The pandemic has had a significant impact on the ability of people to perform at events, to perform at weddings particularly. People have looked to reschedule events. They've looked to move things into next year. A lot of that has come across our desk recently. There are issues surrounding the closure of venues. That is likely to continue on an ongoing basis into next year, because one of the big things, whilst venues are being closed because of the pandemic just now, that's meant they've not had the opportunity to generate income, and it is likely to impact quite significantly into next year, into issues of insolvency and whether venues will survive. Some of you may have seen a map which was published by, I think it was Music Venues Trust over the last few weeks, which has identified certain venues which are on a red list as facing a significant likelihood of failure over the course of the next 3 to 6 months, possibly later in the year. Now, this can all impact. I mean, the fact the venues are able to open up again and you may be able to perform again at some point into next year does not immediately remove the possibility of whoever you're going to be working with being there to enable you to perform in the first place, you know? Another consequence is there may be more significant obligations imposed by licensing authorities in relation to events. We've had one event operator who's been involved in an outdoor event for the last few years, who's very recently had a license pulled in relation to what they're doing, and they were potentially running something at Christmas, and all the indications had been given by their local council, a local authority, that their event would be able to happen, and indeed similar events are happening in neighbouring council areas. However, in this instance, they've had their licence pulled, or not granted in the first place. So, I mean, a lack of licensing or further controls in relation to licensing may impact upon the viability of your contracts going forward. Guidance changes can have impact. Now, guidance doesn't have the force of law, and this is one of the issues that we ran into initially in relation to the pandemic, which was whilst the Scottish Government and local authorities can prevent legally certain things, in relation to other areas, what they're doing may only constitute guidance, and that impacts upon the viability of contracts technically under law, and we'll come on to why that's the case in a second. And the last element, which may come up, of course, is simple things like death and illness and band splits. I say simple things, but practical events which you may be contracted to do something, and you may no longer be able to do it, because of that. A good example, which doesn't revolve around death, illness, or band splits, for example, is where you're contracted to a record company who's going to release your work. The A&R guy who has brought you in really loves the band, and that's why you go into the contract with that particular record company, and then he leaves, and you no longer have a champion in the record label at that point in time. So what can you do in that situation to get out a contract which may not be in your interest to stay in? Okay, if we move on to the next slide, Kira, that would be great. So the first thing that you want to look at where events come up that you didn't expect, or is there a contract in place? If there is a contract, then by all likelihood, that's the first thing that you're going to want to look at. If there is a contract, the first important thing to check is whether it is enforced. Now, if it requires signature, has it been signed? If there are formalities of execution which require witnessing and dating, have all those been complied with? If the formalities of the contract entering into force, the right signatures, the right dates in the right places, if they're not there, then there may be an issue with the enforceability of that contract. If the contract was executed, but it's expired, but you're still acting on the basis of those terms, to what extent is that contract going to apply? So if you're going to go back and look at the contract that binds you with somebody else to say what you can do, what you can't do, what they can do, and what you can't do, make sure that it's in force before you do that, because the picture might be slightly different if you haven't gone through the formalities of execution. We often get issues coming up where people have exchanged a contract, but they've never got round to actually signing it. And they've gone on to act on the basis that it looks like it's in force, and it looks like they're adhering to it, but they've never gone through the formalities of execution. Now, that's a risky situation to be in, because in that situation, the contract will apply, but only to the extent necessary that you have to go back to its terms to allow the arrangement between the parties to be implemented. Now, that means certain terms which may be highly relevant around restrictions and what happens in the event of the unexpected may not apply in that situation. So if you've got an agreement and you've negotiated it with somebody, make sure you get it signed if you're wanting to rely on it. If you don't get it signed, then potentially there's going to be an issue with relying on it. Assuming you've gone through all of that, then the most important thing to do next is to read the contract and work out what it says. If an unexpected event comes up and you're wanting to know or to decide what you're going to do about it, before you make any decisions, read through the contract and see if the terms of the contract have envisaged what could happen in this particular situation. Now, if you're going to want to exercise rights that you have under that contract, for example, to reschedule dates, if there are terms within that contract that deal with the unexpected, things beyond your control, you're going to want to read through those terms and work out what opportunities, benefits, and obligations those terms give to you. It's very, very important to stick within those terms if you're wanting to enjoy the benefits of the contract. There is an argument if two parties have gone into and signed a contract and then decided to, in effect, not act within its terms and to go off and to do something else, then that contract may be disapplied or it may be amended through their acting. So in that situation, if the parties start to disregard the contract, it may prevent you from subsequently relying upon it. So in the first step, look at what you've signed, look at its enforced, whether it's enforced, and look at what it says. And then make a decision on whether you can do something under that contract which will get you to where you want to get to. You know, a separate point to look at is to whether the terms within the contract are legal in themselves. If you're looking to get out a contract, you know, for example, because it obliges you to do something that you no longer want to do because it's too expensive, or because it's going to be very difficult to do, or if the other party is looking at the contract and trying to get out of it, are there provisions in there which may impact upon the legality of the contract? Now, there are two types of contract, in essence, in the world. One is a business-to-business contract, and one is a business-to-consumer contract. Now, with a business-to-business contract where, for example, as a musician, you're engaging with a venue or a record label to provide a service, to provide recorded material, that's going to be a business-to-business contract. Now, what the law will generally do in that situation is say, you guys have got a lot of flexibility to agree what you want. And as a consequence of that, the law doesn't tend to step in and say, put huge controls on what are legal or illegal terms in the context of that contract. So evaluating whether terms are legal or not is something which is potentially not going to help you a huge amount in the context of a business-to-business contract. There are controls upon if there are terms which seek to limit liability of one of the parties. Absolutely. So they are not liable for anything. Potentially those can be struck out. Also, if there are restrictions surrounding what you can and can't do with other people outside the remit of that contract, which are unduly restrictive or unreasonable in the circumstances, there may be some competition law arguments to knock those out of the agreement. But that's really the main points that you're going to be concerned about in a business-to-business contract. Where you're contracting with a consumer, for example, somebody that's booking your band for a wedding, or where you're selling material to a consumer, for example, gig tickets, or downloads of songs, there are many more controls that you're going to be looking at in that situation. Very, very important piece of legislation, the Consumer Rights Act 2015, establishes some fundamental controls over what you can and can't put in that type of contract. Now, there's enough in there to conduct a whole nother seminar on. But some of the main things that you're going to be looking at is if you contract with a consumer at a distance, that's when they're not in the same room as you physically, then potentially they're going to have a cooling off period of 14 days to get out of the contract before it's fully enforceable against them. And they can exercise that right to exit the contract for any reason. There are some exemptions from that which deal with contracts for events and things like that. And there are some specific approaches in relation to digital materials which are worth knowing. But if you have a contract with a consumer in relation to something you're going to do for them, then it is worth getting some separate advice on whether there are any consumer rights that they could exercise against you if you're trying to hold them to the contract, or you're trying to do something with that contract that's going to make whatever proposal you put to them to an extent futile or difficult to enforce. Now, the reason I mentioned checking that before you go out to them is because if you take a hard line with a consumer and they've got rights that you've missed, they may just come back and cancel that contract if it's something they can get out with. So maybe you want to be more pragmatic in dealing with them before, and trying to find a solution to a problem. Laura will come on to a couple of these things later in why it's best to try and settle things or find a way that both people can reach an accommodation in respect of a matter rather than going to court and having a fight. I mean, it's something which, if you can get there, it avoids excessive legal costs and avoids potentially you losing more money than you could lose if you take a really strong and robust stance, which the law doesn't back up in that situation. The one other point I'd mention about illegal terms, which applies both to business and to consumer contracts, is a contract which is induced by fraudulent misrepresentation, in essence, where somebody has lied to you deliberately to get you into a contract. That contract may be capable of cancellation in those situations. However, you're going to need to be able to evidence that. So it is important to keep good records when you're looking at these things. So you can point to that if there's an issue at a later date. Okay, if we can move on to the next slide, Kira. Okay, so the typical contractual clauses that you will see in any contract will involve some of the following. Most contracts deal with termination. Now, what you would see in those terms would be generally a right, for either party to terminate if the other party has breached the contract, and if they've been called on to make that breach better, they haven't remedied it within a certain period. Or alternatively, if they've breached the contract and it can't be fixed by subsequent actions, that would generally provide a right of termination. You would also look at termination provisions which deal with insolvency. So if somebody has entered into a position of insolvency, they've gone into administration, receivership, liquidation, position of bankruptcy, generally the other party is going to have an opportunity to get out of the contract. They're not mutual in the sense that if you breach a contract, you're going to get a right to get out of it, or if you become insolvent yourself, you're going to get a right to get out the contract. These are rights which are generally offered to other parties. There will also generally be clauses surrounding amendment of performance, potentially rescheduling. If they're not in there, if an unexpected event arises, then you're going to have difficulty performing the contract in that situation. So if you're looking at getting something in place, it is worth thinking about at this point in time, what happens if the unexpected arises? What are you going to want the right to do in that situation? What are you going to get paid? What are you going to retain as a deposit? And now maybe in contracts a year ago, that wasn't in there because nobody thought there was going to be something like the pandemic happening. But if you're going into arrangements at this point in time, and it's a sense, it's a question of best to be aware, and best to account for things that you could think of that could happen at this point in time. Because, another pandemic could happen. There could be issues surrounding crossing borders, leaving the EU and things like that. Any number of different things that could come up. Write a list down of what you think could happen. And before you sign that contract, run through those scenarios in relation to that contract and see what would happen under the terms of the contract at that point in time. Absent that, often you see in contracts something which we call a force majeure clause. Now, a force majeure clause is a very simple clause often, which says if something that happens which is beyond the reasonable control of a party, and it prevents them from performing the contract, then they are not liable for their failure in performance due to that event beyond their control. And it's a really it's a get out of jail card where you can't do something because something that you couldn't prevent or control happened and it stopped you performing the contract. Now, very useful, for example, if you're a venue owner, and the pandemic comes up and you've been told to close by your local authority, or there's a law that's come in that's locked everybody down. Great for them. They go back on the normal force majeure clause and say, well, we couldn't do anything about that. So, we can't open the venue and let you in to do this. But of course, the knock-on consequence for you is effectively you're not going to be able to do what you're going to do and you don't get paid. So, whilst it's useful to have these force majeure clauses in there to cover certain eventualities, think through how they're going to work in practice, because they may not work in your favor if there is more risk of the other side being prevented, from performing because of unexpected events than you are, yes, they're very useful if you have something which stops you traveling to a certain location to do what you're going to do. Or if you're trying to deliver materials, recordings to somebody and you can't because, your internet's down and the postal services have been restricted, but is that really that benefit for you really worthwhile when the other side could benefit from this exclusion of liability more so than you can. Think through whether this is going to work in your favor. Now, the other thing which we see in some contracts and we don't see in other contracts is how insurance is going to be approached. Now, if we're looking at events contracts, we will pretty much always raise with the client, how are you going to address insurance in the context of this contract, and what's your insurance going to cover? Historically, you have been able to insure against cancellation of events and things like that. A lot of people were lucky to have certain insurance cover in before the pandemic occurred and were able to fall back on that when their events were pulled. It still would be possible to insure against these things, but it's probably going to be more expensive at this point in time. But there are brokers out there, specialist brokers, that can deal with specialist insurances. And it's worth looking at those things if you're going to potentially be exposed to risk from the unexpected happening, whether it be pandemics, severe weather, death of individuals, personal injury, etc., etc. It is possible at a cost to insure against most risks in this respect. And if you're going to be exposed financially, then it's worth looking at the insurance position. If we could move on, Kira, that would be great. To the next slide. Okay, as I said earlier, it's important that you think about what you're going to do when you've got an unexpected event, you've got a contract, and what the effect of your actions are going to be. If you stay within the contract, then you're going to benefit from its terms. As I said, if you step outside the contract, there may be arguments surrounding that to disapply the contract, and that goes both ways. It may be beneficial for you to try and step outside this and try and encourage the other party to step outside of it as well. So they're losing some of the protections there. But if you do that, it becomes more uncertain what the position is going to be. If you stay within the contract and you follow its mechanisms to deal with the unexpected, then you're going to get the benefits of that contract. So effectively, what you're going to want to look to do is to not act hastily when the unexpected arises. Sit down, work out what your rights and remedies are going to be under the contract, or by trying to negotiate a separate solution and step outside the remit of the contract, and choose a strategy to go forward with and follow through with that. If you don't carry out that evaluation in the first place, then you're going to end up in a reactive position, and it may be more difficult for you to manage in that situation, Now, choosing a strategy is going to revolve around risks and benefits, and it's going to revolve around costs, or again, what you could be landed with and what you're going to get by choosing an option, whether to insist upon performance of the contract, to try and get out of it, or to try and negotiate a separate solution to dealing with an issue. And it makes a lot of sense to try and work out where you're going to go in the first place. One point I'll mention, if you are deciding to kind of rely on the contract and to push that forward, absolutely do check whether there are any particular provisions around notification or sending correspondence under the remit of the contract, because these are very important. If you want to terminate a contract and the contract says you have to provide notification in the following form to the following address, or if you're looking to highlight breach under the contract and require that to be remedied, if there's a particular form of notification that you have to give, if you don't stick to that, you may not have given valid notification. And as a consequence, you may not be entitled to the benefits that the contract provides following that notification being given. So notification provisions within contracts are very important if you're seeking to rely upon that contract to gain some of the benefits that come out of it. Okay, if we jump on from there, Kira, to the next slide, that would be great. So there are some general contractual concepts which are worth mentioning, which may apply to situations which you're involved in. The first of these is what we called repudiation. Now, this is a concept under law where you can infer from the actings of a party that they no longer intend to give effect to a particular contract. In effect, that they have repudiated the contract by not sticking to its terms. Now, absent specific termination provisions, or indeed separate to specific termination provisions in some instances, that would give you a potential argument saying, because they're not sticking to the contract, it affords a right to you to terminate the contract. So the conduct of the other party in not sticking to a contract may provide a right of repudiate. They may provide a right to you to terminate a contract on the basis that they have repudiated. So it's very important to keep an eye on what they're doing and whether it sticks with the contract and whether, it doesn't, and keep a record of that. The second concept I'll refer to is one called frustration. Now, frustration is a concept whereby, because of events which have occurred following the conclusion of a contract, like a pandemic, changes in law because of a pandemic, a contract is no longer capable of lawful performance. Now, in that situation, we can say the contract is frustrated because it can no longer be fulfilled. Now, in that situation, the contract effectively ceases to be. Now, the parties' entitlements in that situation are to be put back into the places that they were at before the contract was performed. So if people have paid you money, then you have to return the money, which is an issue. You're entitled to retain money in respect of elements of the contract that A, have been performed, or B, your expenses in performing that contract to the extent that is reasonable. However, this becomes problematical when you're looking at things like events. If somebody books you to perform an event, say in September or October, and it comes round to September or October, and the event can't take place because there's a lockdown, you have to refund to them the money they've paid you, which is an issue. You've not done anything to perform that event. You've not turned up. You've not incurred any expenses. You've not provided any services to them because they were all going to be provided on the day. Now, this obligation to return the monies, you can term whatever they've paid as a deposit or whatever, but that's still not going to get you out of that obligation because the contract is frustrated that you have to return what they've paid at that point in time. So the way around this is for you to look at your general terms of business in relation to booking, and to build in provisions there that allow you to deal with the unexpected. So what you would want to say, rather than just a simple, we will turn up and perform for you on this date at this location and you will pay us this amount, you would want an additional clause in there which says, in the event of something unexpected happening, we are entitled to offer you a range of different dates. So your booking is not just for this date, it's for other alternative dates. And if you go ahead and offer them, the opportunity to take only one of those alternative dates, then you're able to perform at that point in time. So the contract still is capable of performance because it's not tied to a specific date, and it gives you the right to reschedule in that situation. But you need to have it in there. If it is just an obligation to perform at X place on Y date, then you're going to be stuck. If you're then unable to perform that contract because it is no longer because of other things that have happened. One other point I'll mention in relation to contracts is the idea of mitigation. If somebody is in breach of a contract and you're not in breach, you have an obligation to mitigate your loss under that contract. So if you've entered into other contracts because of this arrangement, if you can cancel and get out of them to reduce your loss, you should do that at that point in time, because it's not a case that you just have this carte blanche right to then recover from them all of the losses that you have incurred, whatever. You are under a general obligation to mitigate your loss in the event that somebody else has breached a contract and you're looking to recover from them. So these are three general concepts which are relevant to any particular type of contract that you may enter into. So if we can now move on to the next slide, Kira, that would be great. So I'm now going to pass over to Laura, who's going to talk about the practicalities of disputes under contracts and hopefully entertain you more than all the dry legal stuff that I've given you, and tell you about what actually happens when you get into a dispute. So Laura, over to you.
No problem. So what I'll do is I will cover off in the slide. You obviously see there are 5 headings. I'll sort of cover off in sort of general terms what each of those options provides you with. And then I'll just invite some questions. I think probably the best way to deal with disputes is to, or to really address what happens during disputes, is to sort of invite questions from you guys and address head on what your concerns are. If you were to get to this stage, and how each of you would like to sort of address sorting these disputes out, if and when any, or if any have arisen to date. As I say, just fire out some questions and Jamie and I can do our best to answer them. So the first item in that column on the left-hand side, of advice and knowing where you stand, negotiation, alternatives and amendment, legal letters and court. I would say that is very much the order that you want to approach disputes. So your starting point, the evaluation that Jamie had touched on earlier, where you're looking at your contract and you're evaluating what your options are, that's really going to be your starting point, because that's going to let you know whether or not you have a basis for a court action if you were to get to that stage. Have you got a basis to try and recover a sum of money, or have you got a basis to try and defend or hold on to money that somebody else is trying to get from you? And that's going to be your contract. That's going to be your starting point. And as I say, that evaluation that Jamie has talked us through is going to give you your starting point. Then we get to negotiation. That would always be your next step. So you're looking at this and you're saying, okay, I have been approached to return sums of money because I can't perform on this certain date. The contract is frustrated and the party they want their money back. The first stage is working out whether or not you have provided any services to date which they have to pay for and which you can delete or take off from the sums that you would need to return to them. As Jamie touched on, if the contract is frustrated, the parties are put back in the position they were before the contract was entered into, and therefore any money paid out should be returned, and it's as if the contract never existed. If, however, you have provided some services to date, so for example, if there have been any instances where you have done a sort of performance, or they have asked you to play for them at another venue, just sort of a taster session, or if you've provided any sort of sound bites or you provided any information to them that you would ordinarily charge for, if there's a cost factored in for those can be taken off from the sums that you would then have to return to the consumer or to the person that you're going to be providing the services to under the term of the contract, even if the contract is frustrated. And what you sort of in that negotiation process, you'd be saying, okay, I owe you, I need to return X to you, but you need to pay Y for the services I've provided to date. So I'll return the balance in sum, which failing, if obviously in your interest, the ideal situation would be to have the dates rescheduled. So for example, if it's a wedding, is the couple intending to get married later in the year next year or the year after? Are you free on this date that they've rearranged for? And are you able to provide the service but at a later date? And in those circumstances, it's always going to be in your interest to ascertain whether or not you're able to perform the services at a later date, because that then lets you hold on to the deposit money, and that because the contract isn't frustrated in those circumstances because you can perform it, albeit at a later date. And if you're getting into that territory as part of that negotiation, you're then looking at alternatives and amendment. Can you amend your contract? And one of the key things to sort of concentrate in any contract amendment is when we're touching on the force majeure clause. Force majeure, COVID is obviously a force majeure event in the sense that nobody anticipated it, and therefore it's an event which was out with anyone's control. And the natural effect of that would be, the starting point would be, well, the contract is frustrated if it can't be performed. COVID is now a known entity. And so in any amendments to any contract, you should be looking to amend into that contract what happens if there's another lockdown, what happens if, whether that be regional lockdown or in a tier system or a national lockdown. COVID is now a known entity. What do you want your remedy to be? And for in the interest of both parties, what happens if there's another lockdown? As I say, that's no longer able to be relied on as a force majeure event because it is now a known entity. So when you're carrying out your amendments to the contract, just bear that in mind, and it's always worth having a sort of position drafted into the contract to work out what you do in those circumstances. Of course, if there's no negotiation and you're at loggerheads with the other party and there's no scope for amendment, then you're then looking at, well, what's my remedy? Do I have a basis to raise a court action? Now, the key components that will dictate both where you want to raise your court action, and both in terms of the actual court and in the jurisdiction, and of course which court you would raise in, is, does the contract have a provision, a jurisdiction provision in it? Does it have a contractually agreed provision? Is the contract governed by English law? Is it governed by Scottish law? If it's governed by English law and you were to raise proceedings in Scotland, you would still have a basis to raise proceedings in Scotland based on, for example, the place of performance of the contract. So quite often you'll find contracts in error have English law provisions in it when it's quite clearly a Scottish contract and the place of performance is in Scotland. You could still raise in Scotland. The other side might say, well, this contract is governed by English law. You still could argue that, well, actually, no, this contract was to be carried out in Scotland, and that would satisfy one of the jurisdiction requirements in terms of the Act to allow you to be able to raise in Scotland. So you're looking at where in the UK can I raise my court action? And then once you've satisfied yourself, let's say for talking sake at Scotland, the value of your loss will determine whether or not it's raised in the Court of Session or in the Sheriff Court. And if in the Sheriff Courts, so anything that is under £100,000, you can raise in the Sheriff Court. And if it is in the Sheriff Court, is it going to be an ordinary action, so anything in excess of £5,000, or is it going to be a simple procedure? And a simple procedure is actually quite a useful tool. Simple procedure is designed for parties to be able to run the actions themselves. It is simple procedure. The name is what it says on the tin. It is a very simplified procedure. It's actually quite helpful as a lawyer to remind yourself of some of the rules when reading the simple procedure rules. It's written in layman's terms. It's really easy to use. It's a really, really useful tool. And so if you're suing for sums under £5,000, that is the most effective way, because you're saving yourself legal costs. You're saving yourselves. And you're also mitigating, going back to Jamie's point, you're mitigating your own losses from a personal perspective. You're sort of keeping a rein on how much your overall loss is going to be. But again, I say this to clients all the time, court is really the last resort. That is not really where you want to be. And, as a litigator, that's quite an odd thing to say, but you see it happen all the time. Court actions tend to be drawn out, not so much simplified procedure. Simplified procedure cases tend to be over and done within a couple of months because it's designed to be a speedy, quick resolution to disputes. If you are seeking to try and recover larger sums of money, court actions can rumble on for years and years, and cost of those can end up exceeding the sums that you're suing for. So really your ideal would be to be in a situation where you're negotiating, and then if you're looking at the sums of money versus how long it's going to take to recover them versus all the other sort of additional time, etc., that you're going to spend trying to recover those, you're really carrying out am I going to cut my losses exercise here. You look at this and think, right, overall, the grand scheme of things, yes, I have a basis to recover the sums. Yes, this is a huge sum of money, and yes, I'm going to go after this. Can you raise it as a simplified procedure action? Then that's ideal. Otherwise, if you're looking at small sums of money and the contract provisions are a bit iffy and you're not entirely sure whether or not you've got a basis to recover, at that point you look at it and say, do I cut my losses and just write this one off? But that's the kind of thing that you would eke out in the sort of first part of that process, which is, again, advice and knowing where you stand. So that's the evaluation exercise that Jamie has talked you through, the negotiation and working out if there are any alternatives and scope for amendments to your contracts. So I think probably that sort of is a whirlwind covering all those points. And I just wonder if there's anybody's got any questions that they want to address, whether it be in relation to disputes per se or touch on any of the points that Jamie had covered before.
Yeah, no, I mean, thanks, Laura. So, I mean, the points that you made on disputes there are very helpful, and I'll give you some practical examples of things which are kind of kicking around on my desk at this point in time. I mean, we have one matter where a guy has paid over money to another party in relation to a proposed business, and essentially has been suffered very badly at the hands of the other party. But the problem is he never got anything down in writing in the first place. So whilst he is adamant that he wishes to raise some sort of court proceeding to deal with this, to try and get it back, and whilst he might morally be in the right position, it's going to be very difficult for him to actually overall get back what he wants to get back. The one thing that would be certain in trying to get it back is that he's going to spend a whole lot of amount of money on lawyers in trying to do that. So, in that situation, because the evaluation of the position, it isn't strong, and the costs of trying to do something are going to be quite high, it doesn't make it sensible to go down that road. In another matter, we have another party trying to recover monies from our client, who are probably due to pay those monies over. But the other party's position, for a number of reasons, it's going to be cumbersome and difficult for them to seek to recover those monies. So in that situation, we're just making it a little more difficult for them with a view to going in of making a lesser offer that you wanted X amount back. We'll give you a bit less, because we know that if you're going to have to deal with this through, more complex proceedings, it's going to cost you a load of money, which you're not going to get back. So why don't we just not do that at this point in time, and you take our offer? So I mean, strategically in negotiation, there's a lot of horse trading and evaluation to be done in relation to these things, which is often where most disputes end up. I mean, like Laura, of the disputes that we see, maybe how many of them go to court percentage-wise?
I'd say maybe about 25%. I think the other thing to remember is as well that if you're having an argument about sort of COVID cancellations, let's call it that for an example, as a result of the first lockdown, and if you're still in negotiation with either venues or individuals who you would be providing services to, the court isn't going to look particularly favourably at the moment on everybody was hit by this. Everybody was affected by it. And the court isn't necessarily going to look particularly favourably on anybody who takes a really hard line either which way with this. And people are encouraged to negotiate. If, however, you're in a circumstance where you've had a contract amendment, as I say, COVID's now a known entity. If you're now in a circumstances where you've had the opportunity to amend your contracts and almost put a sort of what happens if there's a second lockdown or third lockdown, I don't know how many, depends how many lockdowns you think we've had so far. It's 500 lockdowns. What happens? Is there a COVID contingency plan? And if parties are in breach of those, then the court will be a bit more sympathetic to that. And I think that the reason for that is that people have now been given the opportunities to renegotiate contracts. And as I say, if, for example, you have people that you're providing services to, I use the example of a wedding because it's probably one of the most hot topics at the moment. You're playing at a wedding, and that wedding is 10 months down the line. It is worth looking to see if you can have a COVID contingency built into that contract, because it protects you and it probably protects them as well. So that is something that is worth exercising during the course of the negotiation. Obviously, a balance has to be struck, because if you're then looking to draft in terms into that contract, which mean that you have to be paid a percentage, for example, of what you would have otherwise been paid had the wedding gone ahead and you'd been able to perform, you might scare them off and they might say, well, actually, I'll just leave it. The contract's frustrated. I'll just, I don't mean, we're not going to call upon you to perform. And then you're looking at repudiation of contract, which then leaves it open to you to terminate the contract, and they might just hang fire and hope that you repudiate. If they don't renegotiate the terms, they might. So to explain that a bit more clearly, you might approach them and say, okay, happy to pitch up and play next year, but what if this happens again? Can we agree I'll get a percentage of my overall fee if you have to cancel? If they say no to that, they say to you, you can still turn up and play, but we're refusing to revise the terms of the contract. That then leaves you with the risk of then having to work out, right, am I prepared to take that risk? Am I prepared to still agree to play on that date? Because they're saying to me that I can still play. They're not offering to terminate the contract, but it's you're, and then in sort of repudiation terms, where they're saying, well, we're not going to amend, and we're not going to say you can't perform. But if you really are insisting on those amendments and you're not happy to perform without them, then that's on you, and then it puts the onus on you to terminate. And again, you walk away. You don't lose anything because you still walk away with nothing. But then it also then leaves you open to sort of renegotiate, entering into other contracts and for other performances that you could play on that date instead, with more favourable terms in your favour, which you may be quite happy to do because you might be booked out. As I say, that might be something to you that you're interested in, but it's just, this is a bit of uncharted water, and that's the problem with all of this. But as I say, if there is an amendment drafted in and those amendments aren't adhered to, the court will be far more sympathetic in hearing disputes in relation to those, rather than being in the sort of first tranche of the disputes, which is still fighting about what happened as a result of a lockdown that was imposed in March, April, May.
Yeah, one point I'd add generally to this, as I mentioned at the start, we have this support arrangement with MU members. If you want to get in touch with us on any instance that you have, we're more than happy to give you a view on what's best for you to do in that situation on the basis of what contract you have in place, what the circumstances of the particular matter are, what has happened, and within the free support that we give. So please do that. And do enjoy that if you have a concern or if you have an issue with a particular event. We would urge you to pick up the phone to us, and it's not going to cost you money to find a way forward on that, If you want to go to court, or of course, if you want us to fire out lots of big, long legal letters, then we'll have a chat about that. But our first bit of advice for MU members is free, and really do. Picking up the phone to a lawyer at the start can solve and remove a lot of heartache and worry, and issues, by enabling you to go forward in the best way, because. When you're in a dispute and you're in an issue, it may be the first or the second time that you've seen this, but we've seen hundreds of these, So you become quite experienced in knowing pretty quickly what's the best way forward to deal with something, Okay, do we have any questions from anyone? Sure, yeah. John.
Thanks, everybody. Thank you both very much. An excellent presentation. It's really interesting, very clear. I just have one question, and this is something that came up in your comments, Jamie, about if you are in a position to try and sort of amend your contracts and you offer a range of dates if the original one is cancelled. What situation are you in if they don't accept any of your dates?
Yeah, I mean, if there's a provision in your contract which allows you, affords you the opportunity to offer them alternative dates which they have to accept, then that's great because you're still in the contract and they've got to accept that. But that's probably going to be more unusual with contracts which were put in place before all of this happened, If you're contracted to perform on date X and you can't do it because of restrictions, then the contract's going to be frustrated. So that's the situation you're in that situation. If there are force majeure terms in your contract, that may impact upon whether you're going to be liable or not, or whether you've got an extension performance to perform the contract. So you'd want to look at that as well. If it's a situation where, you don't have a contractual remedy to deal with this, or the contract's going to be frustrated and you offer them an alternative and they don't accept it. I mean, in that situation, if they stick to that, then it's going to be a case of returning monies, unfortunately, because you don't have a remedy under the contract and it's no longer possible for you to perform it. It is different from the situation, though, and this is very, very important to remember, where, and that's why I mentioned kind of legal restrictions and guidance-based restrictions earlier, because there's a difference between something which is impossible to perform because the law says you can't do it, and something which, the local authority says would really rather you didn't do that, but we can't stop you. The fact that you're contracted to play on date X and you can still do that means there's still a binding contract in place. Just because they can only invite 5 people instead of 50, unless the contract says otherwise, you still deserve to be paid, and if you're happy, whilst you're happy to offer them an alternative date, if they don't agree that, you can still turn up and get paid, to be honest, if there's only 5 people there, because it's not illegal to perform the contract. It's only just, it's not great, but, it's still possible, if you see what I mean. So it depends on the individual circumstances. But going back, if you have things like that, again, this is something we've looked at for members before. So, Dawn will know the times that we've gone through this and looked at the various different variations of permutations of illegality and non-illegality.
And that's also where the comment that Jamie made earlier on about government restrictions, whether it's guidance or whether it's law, is actually quite key. Because if it's just guidance and it still permits for people, for you to turn up and perform the contract, then it's difficult for somebody to sort of terminate the contract on the basis of, well, you can't turn up and perform because, yes, we're still going ahead with our wedding, for example, but we're not going to have you there just because we want to sort of save costs. That's not, if the guidance still allows for, and that's the devil is in the detail of the guidance on the Scottish Government website, really, and it's, I say that it really is quite difficult sometimes to sort of find your way around guidance. So if there's anything you're not sure of, just give us a shout and we'll try and sort of get our heads around it for you.
Yeah, because this came up in kind of the first wave of lockdowns because whilst certain things were absolutely prevented, those preventions only ran they only ran a few weeks into the future. So kind of lockdown 1 was for 3 weeks, and then we'll review 3 weeks, and then we'll review, and then 3 weeks, and then we'll review whatever it was. But we had people coming in going, well, I want to cancel your appearance at that event, which is 4 months in the future because we're locked down. But strictly speaking, the lockdown only lasted for the next 3 weeks. It may still be possible to perform that contract in 3 months' time because you don't know until 2 or 3 weeks before whether you're going to be locked down on that date, if that made sense. So you can only ever know the contract's impossible until you get much closer to the date. But then, because by highlighting that to the person that booked you, alongside, well, I'll be reasonable and offer you alternative dates if you want to reschedule into next year, you establish you've got a strong position, and it makes what you're trying to get them to do much more attractive as a way out of them for it, if you see what I mean,
Thank you very much.
Excellent. Okay.
Dawn, I think you had a question, did you?
Yes, I just wanted to ask about the reality of, certainly my experience in the small claims court in England is judges take quite a sympathetic view to bride and grooms. I've been with members before where the bride started crying in front of the judge and it's just gone entirely their way. Just wondered at what point you thought it was interesting what you were saying about still being able to go ahead with performance if you're only allowed 5 guests instead of more. I'm a little bit skeptical about how that would go down with a judge. At what point a judge would consider that although the performance was possible, it was materially different to that what had been envisaged when the contract was entered into, and at what point the judge's sympathies for that argument might not stand.
Do you want to take that one, Laura? I know in Scotland they're a little more, they're more flexible in England, I think, to find solutions, but in Scotland they're more robust in sticking to what the parties have agreed,
Okay. I do think that, particularly in the I used to call small claims court as well, actually, and it's now called the simple procedure, but let's, for the sake of argument, let's call it the small claims court. In the small claims courts in Scotland, you do have a lot more of those types of disputes, and you will. That's actually going back to one of the issues with raising court action. Once you raise a court action, it's completely out with your control. It's going to be down to whether the sheriff considers it would have been reasonable to expect, so for example, the married couple to still call upon you to perform the contract, and the sort of description of the crying bride. You might find a sheriff has every sympathy with the crying bride as much as we do down in England and Wales. But I think the key component is really, what does the contract say and what does the government guidance say? And as a matter of law, if the contract provides for if the law and the guidance provides for contracts of that ilk being able to be performed, then I think even though the sheriff would be sympathetic to the married couple, they would be saying, we accept your wedding was much smaller than you had initially intended it to be, but for the same reason you've got to pay the caterers, and for the same reason you've got to pay the photographers, you've still got to pay the band. And if you're unable to, and that's where negotiation, you actually have the upper hand in a negotiation set of circumstances before you even get to court, because you're saying, but hang on a second, we're allowed to pitch up and play. So the same way that the caterers are allowed to provide the food, the same way that the photographers are allowed to attend, the guidance still provides for that. So we're able to perform the contract. So the contract isn't frustrated. That then gives you the upper hand in terms of negotiation. And that's where it's a balancing exercise between whether you want to take it all the way to court and have to go through all that wasted time and expense, etc., or whether you want to cut a deal with the couple and say, right, I mean, realistically, it's not great to have to play for 5 people. They don't want that. You guys probably don't want that. So really, it's in your interest probably to try and cut a deal anyway. It then gives you that set of circumstances that you've just described gives you an upper hand in terms of negotiation. But I think that I would be arguing certainly to a sheriff, look, hang on a second, being sentimental about this doesn't really come into it. As a matter of law, the contract is still being able to be performed by my client, and they're entitled to be paid for those services. And you would hope that a sheriff would adhere to what the law is on contracts. But again, that all has to be based on whether or not the government guidance is in your favour and whether you're actually able to perform the terms of the contract. And I think before you even got to that stage, you don't really want to be in front of a sheriff really arguing that you want a couple who are only allowed 5 guests at a wedding to have to pay for a band to perform. And it's also a sort of there's also maybe a reputational issue there as well. So that what you should really be doing in those circumstances is using the upper hand that you would have in any negotiation process and try and cut yourself a deal rather than take something like that to court, because it's your reputation on the line as well as much as anything else.
That's really helpful. Thank you, Laura.
Sorry. Anything else, guys? Oh, Jamie. Jamie, what do you want to unmute Jamie Campbell?
I am just working out how to do that. I think, Kira, do you have to unmute Jamie Campbell? I can't see. There we are. Yeah. So, excellent.
Yeah, no, just a wee question, because unfortunately I've had about 60 weddings this year, all moved, and received nothing for it at all. And because I sort of get a small pension, I get more money from outside music. I've done no money at all, but that's just by the way. But what we found, the first wedding that was cancelled, I negotiated with the client and managed to get, a sum of money. It's probably about maybe 20% or something, and the client was very happy with it. But I then established very soon after that wasn't the way the agency was going. So I then contacted and said, look, it's okay, don't charge it. I felt reputation was more important for me in that sense. But the one that was kind of more troublesome was there's a few brides that wanted to go ahead with maybe just one person, rather than a 6-piece band, just have one person performing outdoors, etc. And again, I felt, health and safety, reputation, I thought I couldn't do it. So I was slightly worried at the time where I stood. But I think, going back to Laura's point about, I think the guidelines were with me in terms of it wasn't really safe, provide music outside, So that was the only one that's really come up. But I think what I'd do next time, I'd maybe contact you guys just for a quick call and say, look, there's this client, so rather than getting much detail. But I think that guideline about legal stuff, I really felt the legal stuff in health and safety was what I was willing to use. I played, and I'm happy to do it, but I felt it wasn't safe. So that was all. Yeah. So that's handy to know the legal stuff.
That's the other thing as well. In these circumstances, that even if the guidance would allow for you to perform, because this is a pandemic and everybody's concerns regarding their own health have to be respected. Yeah. If the government guidelines permitted you to play, but you personally didn't want to because, let's say, you were shielding or you were concerned, or that all has to be respected as well. And so the couple can't force you to turn up. They can't come to your door and march you along to the wedding and force you to stand there and perform. Yeah. So in those circumstances, you can acknowledge quite rightly, look, say, right, the guidelines allow for this, but personally speaking, I'm really not comfortable with this. Yeah. And I won't charge you anything. And actually, the couple's left without a band to perform, but not being charged anything. So that in and of itself is a good deal. And okay, if you're advising the couple, what are they going to raise a court action for? Are they really honestly going to sue for losses arising from not being able to find a band, another band to perform? And what would those losses be? And also, is a judge going to be sympathetic to something like that? So that's another thing as well. Just because the guidelines say you can do something, the guidelines are important when you're looking to, when you're looking at whether or not you are able to insist on performance of the contract. For example, you say to the couple, well, the guidelines say I'm allowed to go. It's not illegal. The wedding guidelines for tiers 1, 2, and 3 say that you can have a band, etc., etc. So you're able to perform. But if personally speaking, you're not comfortable with that, you really just be appealing to the couple's sort of sense of humanity. It's just there's also that as well. Those also that take into account. A lot of this will hinge on, like you touched on, Jamie, your reputation. You felt your reputation was more important than charging that couple 20%, even though they were happy to pay it.
Yeah, absolutely.
And so this is to sort of use a sort of slightly cringeworthy analogy, it's a case by case basis. It really is. You need to just sort of work out who you're dealing with and how you want to move forward with the dispute as and when they arise. And do you want to keep this couple on side? And do you want to be performing in the future for them? If so, that's fine. Do everything you can to be accommodating. Also, whilst at the same time preserving your own financial interests as well.
Yeah. I mean, I had one issue fairly early on in the pandemic for one organisation that had booked a venue, and they'd gone back, we don't want to run it now because, we don't want to run it because nobody's going to turn up for it, The venue had come back and said, don't care. I mean, it's still technically possible for you to do that at this point in time. Therefore, if you want to get out of this, we want you to pay the full amount that you would have paid otherwise. So in that situation, we went back with a counter argument saying, well, you've not made any accommodations or preparations in respect of dealing with consequences of the pandemic. So because you're providing a service to us, you've got to provide it with a level of reasonable skill and care, which includes taking care of health and safety. Because you've not done this, you've breached the contract, So it's starting to get a wee bit silly at that point in time. But that's when the parties got together and agreed an alternative option to rebook and reschedule it for 8 months into the future. So sometimes it can be a case of making enough noise around it to give that bit of uncertainty that people start to think, well, whether it's going to be a big argument, so I might as well just get into something which is actually sorted out and put it to bed,
Yeah.
You'll also take people that will try to take advantage of the circumstances as well, and it's really just using common sense in a sense to work out whether or not this is something which is a set of circumstances which are being taken advantage of by bigger venues, for example, wanting to save a bit of cash, versus, a couple who's going to get married and they're all ready. That's something which is, hugely stressful in and of itself. Coupled with the sort of ever-changing set of circumstances. So it's a balancing act in terms of working out who are you dealing with, what did your contract say, and how do you really want to resolve this? You might have more of an appetite in taking on a bigger venue than you would a couple, and that makes absolute sense. It's just really just sort of
Yeah, but I mean, do pick up the phone to us. I mean, and asking any of these things, it's not a problem at all,
Yeah, I think it's good having that sort of process of it, getting advice, negotiation. It's good I like a process that's useful to know. So I'd get in a position that I've negotiated a few other things for other issues came up. I just need to know them. I've got somebody behind me that trusts what I'm doing.
I spent 7-8 years in artist management and record company work where I didn't lose my phone and it interrupted a webinar. But yeah, I mean, I've dealt with booking tours and cancelling tours and dealing with things when people turn up. So I know what it's like practically to deal with this. So yeah, we're here to help, really.
Good. Great.
Excellent. Okay.
Guys, thank you very much for joining us today.
Yeah, thank you. Great,
if there's any questions, do get in touch with us. I think Jamie and our contact details are on the side, so just give us a shout.
Excellent.
Good luck.
Thanks a lot.
Brilliant.
Thanks, everyone.
Bye.
Bye.
Cheers.
Bye.